Coming up.
Are you concerned, given the broad terms that are used, like harmful content in this bill, that Parliament just ceding regulatory, both rulemaking and enforcement capacity to this regulator in such a broad way could have serious implications on things like you mentioned, like press freedom and freedom of speech?
You said the internet is an ugly place, and I agree with you. There's a lot of good, there's a lot of ugliness. And you said the Online Harms Act is a profoundly anti-free trade expression bill that threatens draconian penalties for online speech, chilling legitimate expressions by the mere specter of complaint to the Human Rights Commission or the new Digital Safety Commission of Canada.
This Guy's Garage. Like and subscribe.
Ms. Barron, I'd like to focus my line of questions on Section 140 in Part 1 of the bill, which is the section that lists the different types of powers that some of the regulator can make and enforce regulations. I note that there's over 25 different areas that the regulatory body would have the power to regulate on. Are you concerned, given the broad terms that are used, like harmful content in this bill, that Parliament just ceding regulatory, both rulemaking and enforcement capacity to this regulator in such a broad way could have serious implications on things like you mentioned, like press freedom and freedom of speech?
Yeah, absolutely. And my understanding is that the platforms are not clear on how this is actually going to work. They've had some conversations, and all of this is said to be, it will be worked out later. From what we know, this will come down to a lot of these decisions about speech that is perhaps close to the line, highly subjective. Much of it we know will end up being protected expression, even if it offends certain people or hurts certain people's feelings. Those decisions will come down to government-appointed bureaucrats, or, mindful of the severe financial consequences of running afoul of the bill to platforms.
Thank you. So it seems to me that a regulator without a legislated duty of care that includes clearly defined terms on what online platforms would be responsible for is sort of putting the cart before the horse in a potentially dangerous way, both from the perspective of delaying action that could protect victims, but also from allowing opportunities for an unelected regulator to place significant restrictions on speech without legislative oversight. Would you characterize that as an accurate fear in this situation?
Yes, I think that the goals that the government has spoken about, protecting children and victims of revenge porn, are pressing. I think it's unconscionable to create a new $200 million regulator to combat those very specific harms.
Would you say that it would be more effective for the government and perhaps all parties to spend time debating a legislated list of responsibilities for online platforms prior to abdicating responsibility, or that first step would be, the better first step prior to looking at a regulator would be for Parliament to define what that responsibility is?
I think that's fair.
Thank you. So with under Section 140, particularly Section H, this section gives the regulator powers to essentially label so-called harmful content. In that, I read it as the regulator would have almost greater authority than the Canadian Human Rights Commission currently has to regulate speech in a very undefined way. Would you characterize that as an accurate take?
I would say it's very vague and virtually unchecked.
So in that, I don't understand. I don't think that Part 1 can proceed. I think fundamentally for me, I am being asked as a legislator to abdicate my power to an unelected regulator to regulate speech in very broad terms. what do you think about that? Like, I fundamentally think that's wrong. And I think it's lazy on the part of the government, as opposed to actually putting forward legislation, which Conservatives have, Bill C-412, a starting point that could define what online platforms are, as opposed to just porting that responsibility with potential impingements on civil liberties to an unelected regulator.
I think part one should not proceed. I think that the objectives of protecting children and online victims are pressing, but there are other ways of enforcing that. We also know that there are huge problems in the courts right now where individuals who are accused of child predation aren't even being tried because of backups in the criminal courts. There are many things that we should look at before we look at creating a three-headed hydra.
Thank you. So Conservatives have tabled Bill C-412. Would you recommend to this committee that perhaps we should be starting with a review of what should actually be in a list of responsibilities for online operators and debating that, as opposed to just porting unfettered powers into an unelected regulatory body that's going to cost $200 million?
Yeah, so you haven't asked me to comment on the substance of 412. We do have some concerns with some of the categories that are listed in 412, but I do think that it's worthy of further study and consideration. And I'm happy to talk about the categories that we have concerns with.
And fair enough. This was the whole point of 412, was to have an open debate about what platforms would be responsible for, rather than just porting that behind closed doors into an unelected regulator and giving them unfettered power to regulate speech or impinge on civil liberties. Do you think that that is something that the government or any member on this committee should endorse?
I'm not making any specific endorsements, but I do think that proceeding by way of law rather than regulation has benefits.
Thank you.
Thank you.
In your opening remarks, you were talking about, the importance of protecting freedom of expression, and that, this is the new public square. I mean, one key difference, though, is unlike the physical town square, the digital town square is not a passive bystander. And we know on platforms, those algorithms can play a role in amplifying some content while suppressing others. And it can have a very real effect of pushing some people into some pretty dark corners. We just heard from a witness in the previous panel, a member of the LGBTQ community, who said that her ability to freely express herself with the status quo is being hampered. So, how would you like to tackle that? Because we're trying to figure a way forward here. How do we protect her ability to freely express herself? Because the status quo is greatly impugning her right.
I didn't see the other witness's testimony, but I will say the beautiful thing about these online platforms is that there are many of them, right? Mm-hmm. There's Blue Sky, there's Twitter, there's Instagram. There are different communities that have different norms, and as we've seen since Elon acquired Twitter, many people have chosen to migrate to Blue Sky, and you have every right to do so. Yeah. And I think putting down further government regulations, especially when we see that apparently the result in that is the ballooning three-headed $200 million bureaucracy proposed in part one, the ends don't justify the means.
Okay, but would you have any comments on algorithmic transparency?
I'm a constitutional lawyer.
Okay, no worries.
Thank you. Thank you, Mr. McGregor, and thank you to the witness.
I'm reading from an article that was published in The Hub, written by you, 28 February of this year. You said the internet is an ugly place, and I agree with you. A lot of good, a lot of ugliness. And you said the Online Harms Act is a profoundly anti-free trade expression bill that threatens draconian penalties for online speech, chilling legitimate expressions by the mere specter of complaint to the Human Rights Commission or the new Digital Safety Commission of Canada. Now, you heard that the minister has parsed out parts 2 and 3 out of this bill. So I'm assuming it's a less offensive bill, but here's in your opinion, now here's my question to you. If we were to also remove part 1 so that all that's left is part 4, is that a good standalone bill? And could that work together with Bill 4112 as well?
So I think Part 4 should be moved forward immediately. It's pressing and urgent, and I think it's really unfortunate that this government has lumped it together with Parts 1, 2, and 3, which are entirely different. As for Bill 412, it does have language that is disconcertingly vague to us. Content that can lead to loneliness, content that constitutes bullying, content that is harmful to dignity. This is also vague and could lead to takedowns of protected content. So I think that bill needs to be debated and studied further.
Okay, fair enough. So, and hopefully we will debate it, and hopefully you will be back to give evidence on that. But my question really is, could the two be debated at the same time?
I believe so.
Like one doesn't contradict the other?
No.
Thank you very much for that.
Repeated yourself several times. You're not in favor of a digital safety commission in the process laid out in part one. You just made it very clear you don't support 412 because it's too vague, which is a word that's been used by virtually every witness who's been asked about it. We've had two categories of witnesses on 412. They either didn't know about it or they didn't like it. So I'll leave that there. But what don't you like about the idea? Because you said in your opening remarks, there's other ways of enforcing, other ways of enforcement, and then you went on to criticize the court process. So where does that leave us?
Well, first of all, the court process, we can look at the causes why there, first of all, we see shockingly lenient penalties being meted out to those individuals who are convicted.
With all due respect, that's an entirely different issue. We're talking about taking measures to remove stuff from the internet. It's got nothing to do with penalties for people who've been charged and convicted. So let's separate the two if we can, please.
Yeah, I think that there are just much more nimble and focused approaches that could go after, one, child sexual exploitation materials and child predation, as well as revenge porn. You do not need a $200 million regulator, commissioner, and also a lot of this, the majority of Canadians that are going to be affected by the provisions in Part 1 are adults who are perhaps communicating spicy opinions online. That is luckily the majority of individuals.
I'm asking you then, what are these nimble and useful approaches? Because so far all I've heard you say is one doesn't work and the courts are no good either. So what is it?
A pared down perhaps office that focuses just on revenge porn and child sexual exploitation.
Okay,
materials.
so some sort of bureaucratic mechanism, some sort of structure in place, just not the one that's being proposed.
It's not my job.
Is that what you're saying?
Pardon me. It's not my job to present the precise mechanism. It's my job to point out a mechanism that would be less offending of constitutional rights.
Okay, well, it's our job to come up with a mechanism and come up with a solution. So when witnesses like you, who come here with a certain level of expertise, come here and criticize what's being proposed, I would really like to hear your thoughts on alternatives. So that's what I'm asking you, if you have any. And if you don't, then that's fine too.
I think I've said all that I have to say on what a future response should look like.
Okay.
But thank you.
Okay. All right. Now, you said something else that intrigued me. You said, I guess this is a sort of internet or social platforms self-regulating. People can migrate from one platform to the other. So how does migrating from Twitter or Facebook over to Blue Sky, which is the current popular social media platform, help address the concerns of the mothers and the families and the victims we've heard from in this study in previous occasions? That does nothing other than go to a nicer platform. How does that address issues like the dark web? How does that create a solution for these families that are victims?
So to be clear, I was answering that question in the context of a witness who spoke about feeling unsafe while communicating on social platforms. I was not answering it in the context of child predators. I think that clearly all of the platforms are aware that this content gets distributed. They have algorithms. They have ways to flag it and remove it much faster. No doubt tragedies still happen, and to the extent possible, I think that should be addressed. But my comment about migrating to Blue Sky was in an entirely different context.
Okay, so if I could sum up your testimony then, you're here saying we need to take some drastic steps to protect children and create a safer online environment, but you're offering no solutions in a way to do that.
I'm saying existing penalties ought to be enforced. Do you think that this content is not already criminalized? Of course it is.